And I'm just going to bring up my slides. Okay. Okay, good afternoon to those of you who are just joining. I'm going to wait a minute or two to let more people sign on, and then we will get started. You will be receiving a copy of the slides and a link to the recording after the session, so you can relax and enjoy the presentation. So I'll wait one more minute. Okay, I think I'll get started with the score slides so we won't get too far behind. Again, good afternoon to everybody. Welcome. This session is on intellectual property. If that's not what you anticipated, if you're in the wrong place, you might want to rethink, but otherwise, I'm going to give you just a short discussion about SCORE, and then we will get into the presentation. So, okay, what is SCORE? We are the largest network of free volunteer small business mentors in the nation. So no matter what stage your business is, we have a mentor who can help you. We are about 10,000 mentors across the United States, and we're all linked. So if we don't have somebody in the Cleveland office or your local office to help you, we can call on any one of those 10,000 to co-mentor and give you the support that you need. So SCORE's mission is to foster vibrant small business communities, and we do that through mentoring and education. We hope that you, as a small business owner, will get all of the support you need to be successful. Certainly in the Cleveland area and across the nation, the economy is thriving because of small businesses. The jobs that you create as a small business owner are really critical to keeping our communities alive. Our volunteers, again, they give freely of their time, they enjoy working with you, and they want to help you. These are some statistics from 2023. You can see over 30,000 new businesses started, 152,000 total jobs. So we think we're being pretty effective. SCORE is for any type of entrepreneur. About 10% of our entrepreneurs are veterans, and over 50% are women. So I'm pleased about that. We do have a code of ethics, so any information that you share with us will be held confidentially. Our volunteers are not permitted to make money in any way from the information that they get from you, and they can't share the information. This is a snapshot of our website. If you go here, you can sign up for a mentor. There are a list of workshops, both upcoming live workshops and also recorded workshops. And then there are many other types of resources, templates for financial plans, business plans, etc. So if you get a chance, go and spend a few minutes exploring the site and sign up for a mentor if you don't already have one. And I'm going to stop sharing. And I'm going to let Michael Steele take over. Michael is one of our subject matter experts in SCORE, and very nicely has agreed to give this presentation today. So sit tight and Michael, take over.
Okay, thank you, Anita. I'm going to share my screen. Anita, would you monitor the chat for possible questions? Because I will not be able to, because I've got 3 monitors and trying to balance that will be hard enough as it is. So let's see. Okay, can you see my screen?
Yes, it's perfect.
Okay, perfect. Okay. My name is Michael Steele, as Anita said, and I am a patent attorney, and I help SCORE members with intellectual property issues, just advising them on getting them started, and the issues that they face. And what I'm hoping today, for all of the people that joined us, is that you come away with an idea of, what the different types of intellectual property are, so you can start to think about how it might impact your business. The agenda, pretty simple, just a short intro, and then we'll cover the IP types, and in each IP type we'll cover some examples, and then leave some time for some questions. So this is just a short thing about me. I won't spend too much time on it, but I'm a partner at the Tiroli Law Firm in downtown Cleveland, and I've been practicing patent law for 20 years. So I've been with the same firm that whole time since 2004 when I was still in law school, and then I became a partner in 2011, and still working. So now one of the questions you get just fundamentally is, why does IP matter? Why does intellectual property even really matter to people? And when I was a kid, there was a great movie that came out called The Princess Bride. And I think it explains to me the fundamental need for IP without coming out and explaining how it works. But in that movie, one of the main characters is this Dread Pirate Roberts. But it's revealed in this movie that he isn't the real Dread Pirate Roberts. He actually got the name. He sort of bought / inherited the name from somebody else that was masquerading as the Dread Pirate Roberts. And that person had taken the name from somebody else. And that person had taken the name from somebody else. So basically it had already survived 3 generations. And it is explained, no one would surrender to the Dread Pirate Wesley, his real name, but people would surrender the Dread Pirate Roberts. And in that case, just using the name, logo, and having the reputation, in this case, instead of goodwill, badwill, got ships to surrender more easily. So even in criminal enterprises, there's a need for IP. And that's strangely why, like, cartels in Mexico often have their own logos and that sort of thing, because they're actually trying to use their notoriety to force out the competition. So it's very it's pervasive, whether people have the authorization to use the government options or not. Now, for legitimate businesses, like I hope everyone that attending this is involved with, it's much better to have the government on your side when it comes to protecting IP. So there are 4 major areas of IP, and you can enforce them through our court system. There are trademarks, copyrights, trade secrets, and patents. Now, my specialization is in patents, but I also do trademarks. Well, I do a little bit of copyright, and I can only advise on trade secrets. It's not really something attorneys, for the most part, specialize in. And we'll get to why in a little bit. So one of the things that you see a lot of on different products that you buy, sometimes you'll see patent number, written on something, or you'll see patent pending. Well, patent pending means they don't have a patent on it, and patent number is obviously the patent that is covering a particular product. So those are simple. But then also you see these symbols here on different products, and a lot of people don't know, what they mean. So TM means trademark. Circle R means registered trademark, meaning that they registered it with the U.S. Patent and Trademark Office. Service mark is basically a trademark for a particular service that something's providing. And the one I like to use as an example is priority mail from the U.S. Postal Service. Priority mail would be their service mark in that case, but it's really the same thing as a trademark. But both TM and SM, when you see it on a product, means that it's not federally registered. It's what they call a common law trademark. And you get it by just putting like a superscript TM on your product. So it's free to do, and it also asserts the name of your business. The circle C means copyright, like a book. Circle P means a copyright on a sound recording. So you might see that on like a CD. If any of you were, as old as me and remember the vinyls and things were sold, they would have that. And then one time I saw this Circle U on a bottle of steak sauce, on A1 steak sauce, and I had no idea what it meant. I thought maybe it was an IP issue. It's not. It actually means it's kosher. So the Circle U means it's kosher certified. So those are just different products or different symbols you might see on products over the years. So let's start talking about trademarks. What is a trademark? A trademark is a slogan, a logo, or trade dress. The logo sort of speaks for itself. You can have like the Coca-Cola logo, the United Airways logo. The slogan is usually, we do, like Avis, I think it says, "We try harder." Great example of a really great slogan. Trade dress is a little bit more complicated. We'll get to that in a little bit. But it's basically a consistency amongst all your products about how they look and what they disseminate to the world. One of the things to understand the core concept of trademark is the need to protect consumers. The secondary benefit is they do protect the business, but supposedly the primary concern is the consumers. That if a company has a trademark, what they don't want is a secondary company that's a rip-off company, being able to use that trademark and imply they have affiliation with the legitimate brand when they don't, because that then creates a bad consumer experience. So the primary victim there is the consumer, because they might buy a product thinking they got something that's high quality and it's really not. So, as I mentioned earlier, you have two types of trademarks that are registered or common law trademarks. Now, if you register a trademark, it's going to cost you some money. I typically tell people that to expect to spend about $1,000 to register a trademark with a trademark attorney, and that's like on the low end for when you have no bumps in the road and nobody else is out there similar. But for free, you can put the TM, the superscript TM, on your logo, and you should be doing that to assert to the world that you own that trademark, because you can register it later, even if you don't have it registered to start. And if you have it registered, you can bring a lawsuit in federal court instead of state court. You can also bring a customs action. There's a lot of things that you can do with a trademark that if you have it registered, that you can't necessarily do with a common law trademark. So one thing I always tell people is, if you're going to bring a suit, which is going to cost massive amounts of money anyway, always register it before you before you bring the suit, or at least try to register it, because the cost of registration at that point is minuscule compared to the cost of litigation. But if you're not looking to litigate, one of the biggest questions is, do I need to register my trademark, right? And with a lot of solopreneurs in this call, every dollar has to really get good value for the client. So if you were a larger company, I would always tell them, yeah, go ahead and register. It's only $1,000. But when $1,000 might be, for your first year, it might be 10% of your revenue, for instance. It's really tough to say. So what I tell people, for particularly small companies, is you need to register your trademark if you're allowing others to use your trademark. And the reason I say that is I run into a lot of score companies where they have a system, like an education system or whatever, and they're going to create their own certification, and then these other businesses might use that certification and present presentations, webinars, and whatever that have that will use that logo. In that case, you're contracting out with third parties how that trademark is going to be used. And in that case, you definitely want it to be federally registered, because you're allowing other people to use it in specific ways, and you want to be able to control that more tightly. Whereas if you're only having your employees, not your contractors, so these are W-2 employees that you're paying half their Social Security on, then usually, and you're creating their business cards, you're controlling how that trademark's going to be used. A lot of times you can get away with not registering it, at least right away. One of the most important concepts in trademarks is that you get their strength based on their use, not on the registration. So the more people that know about the trademark or know about your product, the stronger it is, regardless of if you register it. So what is trademark prosecution, or a trademark infringement? Trademark infringement, after you have the trademark, is determining that there's a quote unquote substantial likelihood of confusion. And what they're concerned with by this standard is, would there be an injury to your reputation, or would there be a dilution of your business opportunity? So, if it's one thing that you have a damaged reputation because it could be a mockery of your product, but it's also like on Amazon, as Anita mentioned, setting up or I've seen with Amazon stores, other presentations here, that you end up with a lot of Amazon stores that come in and they assert that they're legitimate knockoff, they're legitimate products that are actually knockoffs, and then they take away from the ability of the legitimate company to sell the same product. So that's the concern when they talk about dilution of the business opportunities. So I'm going to give you a real world example of a trademark infringement case from 30 some years ago, or 35 years ago. Toyota in 1988 started a new car company that everybody has heard of, Lexus. They were then sued by an already existing company called LexisNexis. And LexisNexis is, for anyone on this call that has a background in legal world will know, LexisNexis is a search engine for lawyers, find cases and that sort of thing. It's an extremely common tool. Well, as the name is almost identical, just one letter off, and the pronunciation is the same, Lexus and Lexus. LexisNexis sues Toyota. And they looked at these 6 factors in deciding if there was infringement. And usually, in most court cases, there will be one major factor that they lean on. So in this case, they look at the similarity of the marks, similarity of the products, the sophistication of the consumers, the predatory intent, the renown of the senior mark, and the renown of the junior mark. In this particular case, the controlling factor was the sophistication of the consumers of LexisNexis. They said only lawyers use LexisNexis. It's a highly sophisticated consumer, and as a result, they will have no problem determining if it's a car company or LexisNexis. So they said that there was no infringement, and that was an unusual case because it's, the very, very similar names. Fortunately for both companies, after this determination, the companies don't have ill will. They even have occasionally a promotion. Toyota run a promotion of win a Lexus on Lexus when you use LexisNexis. So they've continued to coexist in the last 35 years just fine. So here's another example, as I mentioned previously, about trade dress. Trade dress is how your products look and feel. And so I brought a couple of real world examples. I'm a woodworker, and you'll see that I use a lot of woodworking examples in my presentation. A local company in Strongsville named Woodpeckers makes tools, woodworking tools, and as you can see, all of them have the same color scheme. They even have the same font, as you can see on the tools written themselves. So they do that because they're establishing their trade dress. All of their products have a very, very distinctive look and feel. And they do that as much for protecting their trademark brand as they do for growing their brand. Because if you watch a lot of woodworking videos like I do, you can always see in the background when people have woodpecker tools, because they're very distinct and they just sort of stick out. And so they have really been able to grow their brand by just having that, that trade dress. Well, in the court cases, there was a company called Taco Cabana and they're still around today in Texas, that used outside furniture indoors, amongst other things, and they had fountains. I've actually been to a Taco Cabana. It's pretty neat place, but it's very distinctive there. And there was another company called 2 Pesos Tacos that they originally started as a franchise of Taco Cabanas, and they got tired of paying the franchise fee. And so they just made themselves into 2 Pesos Tacos, but really all they did was change the sign. They didn't really change the inside of the restaurants, or not much anyway. So they brought a lawsuit that went all the way to the Supreme Court, and the Supreme Court said there was trademark infringement because a business owner that copies a trade dress may be seen as falsely claiming that his products may for some reason be thought of as originating from the plaintiff. In this case, because everything was so similar, because it had really originally been a Taco Cabana's, then they said, there is definitely a substantial likelihood of confusion by the defendant. And basically 2 Pesos Tacos ended up selling itself to Taco Cabanas, and they got converted to Taco Cabana after this case. So it was a follow-up. Now for a local example, and interestingly enough, another taco restaurant, Barrio Taco versus Condado, Barrio Brothers versus Revolution. In this case, anybody that's been to both Barrio and Condado Tacos, and they have both in Strongsville, can see instantly the similarities. And the reason for that is they were co-founded by the same people, and there was a breakup right at the co-founding, and they agreed that they would have different markets. But then, of course, Condado Tacos expanded, and then this lawsuit got brought. But interestingly enough, the court in this case said that there was no trade dress infringement because Barrio was not distinctive enough. And this was basically saying that their distinction, the name Barrio wasn't distinct, that there were other Mexican restaurants that were named that. They used Day of the Dead, which was extremely common Mexican decoration. They did have virtually the same way to order, but they said that basically that Barrio just didn't have enough distinctiveness on its own to have a trade dress. Therefore, there could be no infringement because they just hadn't distinguished themselves from other Mexican restaurants. This is a tough call because I wouldn't have any question if they were distinct restaurants, but they definitely have enough in common that the first time I went to a Condado Tacos, which was in Columbus, I definitely knew there had to have been a story that they were connected to Barrio somehow. So I can see both sides on this argument, but ultimately um, the court said there just weren't enough features that were unique to Barrio to warrant a trade dress claim, including a lot of the things like the foil wrapped food, mason jars serving drink, and the particular order forms that they used. Like there were too many other restaurants that used similar things. So the last part we'll talk about with trademarks is a problem everyone, I hope every single person here has, is genericized trademarks. And the most famous example of this is the Kingston Sealy Thermos Company versus Aladdin Industries when they lost their trademark on the name Thermos. So originally that was a trademark name and only they could make trademark the Thermos. They said the generic name was vacuum bottle, which nobody used. They couldn't even find any examples where anyone used that. And the court said at this point, the word had become generic. So other companies were allowed to use the name Thermos. So now King Sealy was allowed to use the name Thermos Circle R or an original Thermos, and they were allowed to put it in uppercase instead of lowercase, and the competitors had to use it in lowercase, but now it had become a word in the English language, so they couldn't protect it anymore. And there's a bunch of examples of genericized trademarks. Before I went to law school, I didn't know a lot of these were trademarks: trampoline, dry ice, escalator, flip phone, kerosene, laundromat, videotape. And last year, for the first time, was Taco Tuesday, that a trademark got deregistered with the U.S. Patent and Trademark Office. I often tell people at some point, I won't be surprised if Blizzard becomes a genericized trademark. If you go to any soft serve ice cream parlor, they'll serve something that's equivalent. The McFlurry, the Whiteout, Wizards, I mean, they all harken back to what the Blizzard. And the funny part is, if you ever ask an employee at one of those places whatever like a Wizard is, it's like a Blizzard. I mean, because everybody knows what that is. I remember talking with one person and they said that, well, a concrete mixer was the same thing, was a generic name. And I looked that up, and concrete mixer is reference to frozen custard with a mix in. And as a fat man that has gotten fat on eating a lot of ice cream, because I love ice cream, I can assure you I would never confuse frozen custard for regular ice cream. So I would still stand by that. I don't know the name of a generic term for a Blizzard, because definitely it's not frozen yogurt. It's ice cream with that mix in. So the next major section of intellectual property that will probably impact most of you is copyright. So what is copyright cover? Computer code, advertisements, any type of original work that you can store on some sort of medium, whether it's a computer or written, on paper. One of the misunderstandings of copyright is that you have to register them, and you don't. They're created as soon as they're stored on on that medium that somebody else can reproduce them on. You have to register them if you want to bring a suit, and we'll talk about that in a minute. But the big problem with copyright is what they call the fair use doctrine, is where you have non-commercial use of copyrighted material that does not diminish the copyright's owner ability to make money from that work is considered fair use. So the generic form of that is, if I want to refer to the Cleveland Browns, winning and losing a game, even if I, doing it in online or something like that, I'm allowed to talk about the Cleveland Browns. I'm not allowed to use their logos and things, but I am allowed to reference, that they're a football team in Cleveland. The pictures here I have, once again, dating myself, But this was a great example of copyright really working well. Was Vanilla Ice used the same tune from the song Under Pressure from Queen, and there's Freddie Mercury, and he was able to license that name, remix it for his own use, and he wouldn't, he wasn't infringing because he was operating under a license. But that's just a great example of a derivative work, where he took the original form and transformed it into something new. So you get the question a lot of, do I need to register my copyright? And the first thing is you have to register a copyright before you file in federal court. And you basically can use your registration as proof of ownership. It adds a lot of evidence. And quite honestly, most people can register a copyright on their own. It's definitely not harder than filing your taxes. It's easier than that. There's forms online on the Copyright Office and everything else. It can be a little bit of a pain. The only time that you really need an attorney is if, like, let's say you're a photographer and you're copywriting thousands of pictures at a time. Then you need, like, an attorney to help set up the process in a bulk, a transfer. But after that is set up, after a couple of sessions, then you can sort of take it over. But what they don't want, the Copyright Office doesn't want, is everyone registering everything, especially for things that are never going to be, infringed or they bring a suit for. A good example is, let's say, your evening news every night. It's a different show every night, and there's going to be a copyright associated with that. A lot of television companies aren't going to bother to register each individual performance just because it's so much work. They would only do that if they thought that a particular episode was likely to be infringed, if they had some sort of scoop or something like that. The Copyright Office would just not be able to function if everyone had to copyright everything at the time it was created. So you really need to focus on, am I concerned about this being infringed, or has it been infringed? And in both cases, then you go ahead and register it. One of the other questions you get is, who owns work, and how is that, how is ownership established? So we'll give the example of photography. The general rule in photography is whoever takes the picture owns the picture, even if they're using somebody else's camera. But if an employee takes a picture, so what's called work for hire, it's assumed that the employer is the author. So if you have an employee take a picture for you, the company that owned it would be considered the author of that picture, the owner of that picture. However, do not confuse that for contract work. I get this. This comes up much more often when somebody says, well, what about work for hire? When they hired a contractor. If you hire a contractor, you have to negotiate your IP rights separately. And so if you want to own it, you need a full assignment. That's what it's called, an assignment of the copyright to you. Otherwise, it's presumed that the contractor continues to own the copyright. And a fun example of this is a tattoo parlor. If you go to a tattoo parlor, you've hired a contractor to give you a tattoo. You might not have seen it that way, but that's ultimately what you have, is that, a contract for a tattoo. The tattoo artist still owns the design that they've given you effectively a license to use it on your arm or wherever. But when you would not be allowed to say it's your design and start putting it on anyone else's body. I mean, regardless if you're capable of doing that or not, you wouldn't be allowed to without the permission of the tattoo artist, without infringing on that tattoo artist's copyright. So that's a good example where you own the version that's on your body, but you don't own the design of the tattoo that might be on your body. If you want to own that, you have to pay extra to the tattoo artist or whoever your contractor is. So let's go through some examples of copyright infringement. The legal test is substantial similarity. And this these two pictures here, the one on the left was an artist illustrator named Kerr, and Kerr brought an action against New Yorker magazine. And as you can see, the two pictures are relatively similar. They have this mohawk skyline. Looking at the facts of the case, allegedly, Kerr says that the artist Kuntz, who New Yorker had hired to do this front page, had actually attended one of his art galleries, and this particular picture was at that art gallery. But the court said the picture on the right wasn't considered a derivative work, and it wasn't considered to infringe because even though it was similar, that the two messages provided by the two different images were different. The one on the left, very edgy, aggressive. It uses, black and white pen etching, hash etching. And the one on the right, very colorful, serene, relaxed, trying to sort of convey a different message. And so then they said there was no infringement. Looking at the factors that the courts consider, they look at the uniqueness, unexpected idiosyncratic elements that are repeated in an infringing work, the appearance of errors and mistakes in both works. That shows like a direct copy. There's also one we'll talk about a little bit, fictitious entries, also known as paper towns, or obvious and crude attempts to show dissimilarity. And the best example that I have for that is if you've seen the Buy More there was the TV show a few years ago where there was obviously Best Buy ripoff, and then there was the movie Coming to America where they had McDowell's instead of McDonald's. Those were movies, and that would definitely be considered a parody, which something I didn't mention earlier, but you're allowed to infringe if you're making a parody. But if you had actually opened a real McDonald's, or a real McDowell's, that would have almost certainly been an infringement. So here's a case where we did have copyright infringement. On the left is a famous New Yorker magazine cover called The New Yorker's View of the World. And it famously shows how the New Yorker is looking out their window, and all of New York is shown in great detail. As soon as you reach the Hudson River, you go to Jersey, then a few random cities, Chicago, and then Pacific Ocean. So, if it doesn't happen in New York City, New Yorkers just don't care about it. It's sort of, and it's something common that this particular image is referenced for. So, in the mid-'80s, there was this movie, Moscow on the Hudson, and one of their movie posters showed the picture on the right. And the court said this was, clearly a derivative work. The illustrator for Moscow on the Hudson admitted that he was inspired by the New Yorker's View of the World. The Columbia Pictures, the movie company, tried to defend on the position that it was a parody. As I said earlier, parodies aren't going to be infringement, but they said it wasn't a parody of the artwork. The artwork may have been a parody of how New Yorkers view the world, but it was trying to convey the same satirical message of the original work. So the parody argument didn't fly here, and so they determined that there was copyright infringement. There's another example, as I mentioned, about paper towns. So there was a movie called Paper Towns a few years back, and the word came from the concept of back when cartography was still a common job that people would have. They would make maps, and they would add fake towns called paper towns to the map. That way, if a copier came along and copied the map exactly, and they added one of these paper towns, they would know that they used the original work as the motivation, because the town didn't exist outside of this map. So in that case, they had dead to rights, so to speak. In similar world in computer programming, when they're looking at copied material or derivative works, they often look at the commenting part of the code. In this case, C versus PK, where they saw the code have the same comments, including misspellings in the code, and it was deemed a derivative work. And the reason I bring up this case is because most people don't know the history of why we have zip files today. Originally, C created this .arc compression format, and a guy named Phil Katz created this PK-arc, and he worked for C originally, and then he created his own called PK-arc that was, the same thing. And they sued him for copyright infringement, and they won, and PKware changed their protocol compression to .zip. And if you've ever heard of PK-zip, this is where it all came from, and this is how zip files were created. And this was actually a better protocol anyway, but that was the settlement. Interestingly enough, I remember when this case came out, and zip was both better and faster than .arc. So by this lawsuit, even though they won the lawsuit, they ultimately lost because almost everybody quit using the .arc format instantly because it was both worse. It didn't compress as well, and it was significantly slower. So great irony there. This next example, I'm going to have to give a quick example of an API. Now, I know anybody that does computer programming is going to think I'm talking like I'm explaining, I sound like a kindergartner when I talk about this, but, for you that aren't familiar with what APIs are, an API stands for Application Programming Interface. So when you write a big software package, a lot of times you will publish an API. And what the API is a set of computer instructions that you can make particular calls for actions on the server, on the bigger software application. Some people analogize it to a waiter. So your user would be, you write a software application, and then the waiter is the API. The waiter then takes your order in the form of computer code and goes in the back, gets the food, in the form of the back-end operations, and brings it back out to the customers, and again, in the form of the application. So a real simple example of using an API is Twilio. And you can see here some computer code that you can send messages to Twilio to cause it to send text messages to particular phone numbers if you follow this, procedure. The idea here being that you can do this instead of using your phone, so you can write computer code on a desktop application that can interface with the Twilio system in order to send messages. I bring this up because there was a major Supreme Court case 3 years ago, Google v. Oracle, where originally Java, the programming language, was owned by Sun Microsystems, and then they sold to Oracle. They sold the whole company to Oracle. So that's why Oracle is the defendant here, or the plaintiff here. But when Google was creating their operating system, the Android operating system, they wanted to have Java programmers because there are already hundreds of thousands of them available, and because Java is so successful. And they originally negotiated with Sun to license that technology, but those negotiations broke down. So what they did was, going back to this example here, is they copied the APIs right from Sun Microsystems, but then wrote their own underlying server applications, if you will, in order to the back end called object code, operated differently. And that allowed Google to hire Java programmers, not creating a new programming language, and use all these Java APIs without actually using Java code. So they, was a way around having to pay that license fee. And the Supreme Court said that was considered fair use because they said that Google only used 0.4% of the total source, even though they did the same things as the Java code. I really didn't agree with this decision by the Supreme Court, but this is the law of the land. And they said that Google copied that code, not because of their creativity, beauty, or even a sense because of their purpose. It copied them because the programmers already learned to work with Java. And it would be difficult to attract programs to the Android system without them. And I thought, and that was the reasoning for, finding there was not, copyright infringement. But in my mind, it should have been the opposite, just because Sun had sunk so much money into disseminating knowledge on how to use Java. Basically, Google was able to piggyback that and not pay that fee. It's sort of what they call a free rider situation. But that's the law as we have it today, so I can't argue with the Supreme Court. This case makes it clear, though, that you can basically take somebody else's API, write underlying object code, have your code be compatible with the API and not pay a fee and under the fair use doctrine. So it's a little complicated, but okay. So the next one, as I mentioned, is trade secrets. I'm not going to talk too much about this. They sort of speak for themselves. A trade secret is the secret sauce of your company, for instance. And you keep it secret by literally maintaining security around it. Two of the most famous examples are the Coke formula and the KFC formula. The KFC formula is apparently so secret that they actually have two factories. They send half the ingredients of the 11 herbs and spices to one factory, half to another. And then a third factory actually mixes them. So no one company has all of the information. A trade secret lasts as long as it's maintained. And, so it literally can go on forever. What constitutes a trade secret is basically the economic value that you get from, that particular secret that you have. The problem with trade secrets is that once they're out in the wild, you might even be able to bring a trade secret case against the company that stole the trade secret. But if they publish it on the internet, you'd be limited to only that one company. At that point, all of the other companies can use it without violating a trade secret. You can only bring it against the company that actually stole your secret. And as your company expands, you have more and more employees, it's always really logically difficult to keep things a secret. So that's that's the good and the bad of trade secrets. So now we'll come to my section of the law, patents, and talk about them for a few minutes. We won't go into too much depth because small businesses typically don't have a lot of patents. But there's two main types of patents. There's design patents and utility patents. A design patent covers what a device looks like, what's its aesthetic properties. A utility patent is on what it does. It's important to note, the most important thing to learn about patents is they're a right to exclude others. They're not a right to operate. So in the early 1900s, when electronic circuits were new, one company came up with the triode, which is an amplifier, and one company came up with the diode, which is a rectifier. But you can't make the triode without the diode. So the diode was out first. Another company makes the triode, but they need to cross-license they need to license the diode in order to make the triode, or they won't have the right to make that because the company with the diode patent can stop them from making the triode, because you've got to infringe the diode patent just to make it. So in those cases, they were able to both make the diode and the triode, and they were able to keep everybody else out of the market, which was a huge advantage to both of them. So it's always a good example of how the patent system worked really well. Design patents, as we show some simple examples here, we show like the game Simon on the right side, or the Mr. Potato Head in the center, a Monopoly game. These are really going to be important for going forward in the near future because so many options for 3D printing exist. So a lot of people as a hobby are creating 3D prints. They share them, which is great, but more and more people also are seeing ways to make businesses. If they spend a long time designing something that looks particularly good, or that on a 3D printer or on a small CNC machine, they can use a design patent to protect them. And design patents are relatively inexpensive because most of the work is done by the inventor. These images are the most important thing in a design patent, whereas a utility patent requires like a 30-page document from a patent attorney. So patent infringement is much more straightforward than the other types of infringement because a utility patent has these claims in it. And each claim has a certain number of elements, element A, B, and C. And in order to have an infringing device, you have to have all of the elements of a claim. So if you have a claim, or if you have a device that has elements A, B, and C, it infringes. If you have a device that has element A, B, doesn't have C, it may have 1,000 other elements, but it doesn't have C, it's not infringing. It's very straightforward in that. This slide is included. I won't go through all the examples, as sort of a reference point when you look at it later. If you want to know like how infringement is determined, but that's the most important thing, is to understand that you have to have every element in an infringing device. So the real world example of this is SolStop versus Bosch. So this was actually an International Trade Commission situation. So there might be some sound here. I'll try to turn it off, but it doesn't always cooperate. I'm going to play these videos. So if you've ever used a SolStop,
the patented safety feature is made possible by a sophisticated mechanism. But the concept is actually very...
The hot dog is a stand-in for your finger. And if you touch your finger to a SolStop blade, the blade drops beneath the table. With Bosch, they do something very similar, except that in their case, the blade doesn't run into a break. If you look at this one in more detail here,
the blade carries a small electrical signal. This charge is continuously monitored by a digital signal processor. When skin contacts the blade, the signal changes because the human body is conductive. This change in signal triggers a quick-release aluminum brake. A heavy-duty spring forces the brake into the teeth of the spinning blade. The teeth dig into the aluminum, stopping the blade cold.
Okay, and that's very important for my explanation here. And they don't really show in this video how the React's blade works, but basically it uses airbag technology to set off a little explosion in the top and forces the blade beneath the table. And so in the International Trade Commission, which handles importing the goods, this wasn't an infringement case before a regular court, they brought two different patents. SolStop brought, brought two different patent infringement cases. One of them had this element wherein it has a reaction system associated with detection of a cutting tool, wherein the reaction system is configured to retract the tool below the work surface within approximately 14 milliseconds after a dangerous detection is detected. So the dangerous detection being your finger, and it drops below in 14 milliseconds. And they determined that there was infringement here. This other patent that they said wasn't infringed by Bosch mentioned this brake configured to engage the blade. As I mentioned, they don't use that at Bosch. And so Bosch didn't have this last element. So even though they had all these other elements, they didn't have this last element, so they didn't infringe, but they did infringe on this one. And so from this, SolStop was able to stop the importing of this device. And since this device was made, the Bosch table saw was made overseas, they were able to stop it from entering the US market. And that's a oversimplified example of patent infringement, and it's really a long and drawn out process that I won't bore you with anymore. But that's a good example of when the system operated like it was meant to. But that's what I've got, and now we can open it up for some questions. I will end my
Okay,
share.
we have lots of questions, Michael.
Okay.
let's see. First one, how do you put a value on your company's intellectual property, i.e. logo, when preparing to sell the company?
So a lot of that will come down to the the client list that you have that are buying from your particular company. So if they're, it's sort of like if you change the name of the company, would all of the clients disappear overnight? Because like, let's say it's mainly a service-based company, that would be the case. If it's just a products-based company, then the valuation is a little bit lower because the products would stay the same. It would still be valuable, but it would be, you'd have to reduce that somewhat. So a lot of the IP valuation goes into how large the company is and how much goodwill your particular company has in disseminating its name and associating your products with your name determines the valuation. There's an entire career path involved in IP valuations. That's only the 10,000-foot view, but those are the factors that are looked at. If you are looking to sell your company, that is definitely an expert that you need to consult with, would be an IP valuation specialist to give a more accurate view of what your particular company's business would be worth based on its IP.
Okay, second question. Can something like, and these are capital letters, WWJD, be a trademark? So basically an acronym.
They can be, you have to do, in that scenario, you have to do a search, and just when you have WWJD, there might be another company out there that's using that. One of the ways that you can still get a trademark is the stylized way in that that the WWJD is written. So if you look at the Coca-Cola bottle, it's not just the name Coca-Cola that's got a trademark, because that has a trademark on it, but the particular script in which the Coca-Cola logo is written is trademarked in itself. And so WWJD, if you have, I'm making it up as I go along, but it's like at a slant or something like that. That particular form of of your logo can be trademarked, even if somebody else has WWJD used for a completely different purpose.
Okay. Open. If I mention a retail brand in my online articles, should I also include the registration mark?
Yes. When you know something is a registered trademark, it's good practice. It's not always required, but it's good practice to acknowledge that mark in your writings. A lot in legal world, we would typically, if we're referencing a trademarked work, we would put it in all caps, circle R, into our writings to emphasize to the reader that we know that mark belongs to somebody else. And we usually would say, circle R, owned by whatever industries or whatever. Right? We would make no effort to imply that we owned it or anything like that. It's like, that's one of those things that the more attention that you bring to somebody that you don't own it, gives you a better argument that you're using it for what's called fair use, because you're recognizing you're just referencing it and you're not trying to do any harm to the product.
Okay, if I have my own photographs included with my online article, do I have to put a copyright on them? I'm not selling the photographs. They are used to complement the article.
So in that particular case, this goes back to what I was talking about with the concerns on registering a copyright. You really only need to worry about that when you know that there's either actual infringement or there's a big potential for infringement. If you start seeing the pictures, out there, and you're saying somebody is using them without permission, you can go register your pictures at that point and then bring then assert your copyright against the people that are allegedly infringing. If before then, it's just very cumbersome to register. Like if your website or online article is changing all the time, it can be just cumbersome to register. However, if you know that it's going to be permanent and you're going to be, using that the same set of pictures for a long time, then it might be worth the effort to go and copyright. It's really just a matter of how likely you are that somebody else would infringe those pictures and use them for a different purpose.
Is there a way to schedule a meeting consultation with you about correctly separating IP between two organizations I run? So I guess they'll have your contact information when we send out the slides and the recording. So
yeah, just as a public service announcement for everybody on the call, the way it usually works is, as being a subject matter expert, is if you contact your SCORE mentor and say you have an IP issue and you're hoping to speak with an IP subject matter expert, they'll often refer it to me. I know there's some other IP experts, subject matter experts as well within SCORE. But that's often how that would work. I'm not saying you couldn't send me the message directly. I'm just saying, like, if you don't remember who I am or anything, bring that issue up with the mentors, because they're usually well versed with what subject matter experts are available. And it's not just for intellectual property, but for anything. Say, does this need, if something's outside the scope of your mentor, does this need an expert? And they often are great resources to reach out to subject matter experts.
good. Okay. Why are trademarks canceled after a period of years? Shouldn't the registration last throughout the life of the company?
So that's a maintenance fee issue and a use issue. The trademarks are canceled when you either quit paying the Patent and Trademark Office money to maintain the right, or when you quit using the trademark. Now, if you quit paying the registration fee and you keep using the trademark, I don't know why you would do that, but if you did that, you'd revert back to a common law trademark. It becomes public property when nobody uses the mark for a certain amount of time. And the best example that I'm aware of this is Anchor beer. The Anchor steam beer was produced sometime in the 1800s by a bunch of different breweries and up until Prohibition. After Prohibition, nobody besides the Anchor Brewing Company made steam beer for the longest time. And as a result, that particular trademark went from being a publicly owned trademark to a privately owned trademark, because they had been the only ones using it, and they never abandoned the trademark. That's why they were the only company able to make steam beer, even though originally lots of companies were able to make steam beer. Now, suppose that now that Anchor has gone out of business, I'm pretty sure they're going to sell that trademark to somebody else, at least in bankruptcy. But if they didn't, that trademark is going to revert back to the public and become generic again, and other companies would be able to make steam beer. So it's really a matter of, you can prevent your trademark from expiring by following the proper fees and procedures to continue to use your trademark and make sure it stays out of the public domain.
Is it true that patents can only be granted via an attorney?
Is that true? No. However, drafting a patent, I have been practicing for 20 years, and in my mind, it's like asking if you can do surgery on somebody with no training. Technically, you can. Usually, the results will not be favorable. So it's not something that I ever recommend, simply because you end up just the government fees. Forget the attorney fees. The government fees are several $1,000s. And the people that I've seen to draft and prosecute their own patent application, what they end up with in the best case scenario is they end up with a plaque on their wall that says they have a patent that they cannot use because they didn't understand patent law. But just as likely is that they won't manage to do the process at all. And as a result, the case will go abandoned, and then all of that money, time, and effort will be for naught. So it's definitely not something I recommend, but technically you can do it.
How to make a broad provisional patent application? Also, how long should it be?
A provisional patent application has no particular form, and anybody can do one, but I don't even recommend them for my clients. I think they confuse issues. That said, a good provisional patent application describes your invention in a way that would support all of the different features that you could use then to hire an attorney to draft a non-provisional application that could get they could get rights from the patent office from that provisional application. The reason why I don't recommend that for lay people is the times that I have worked with people that have done that is that their provisional application doesn't include certain features they forget to, and as a result, when I write the non-provisional application, they really don't get the benefit of the filing date of the provisional application. It's basically they'll have 2 dates on the application. So you have to describe it in good detail, but there's no like format that you have to follow like you do with a non-provisional application. So it's a little bit more free form, but the standard is still the same. You still have to show how to make and use the invention in a way that would be understood by quote unquote one of ordinary skill in the art.
Okay, I'm working on a provisional patent using a design app, but in order to fully set up, I'll need to full explain on the operational of the device. So would this be both utility and design?
There is no such thing. You would have to file both. You'd have to have a design patent and a utility patent, which is common. That you would have. The Rubik's Cube, for instance, had many design patents and utility patents on it, and one is how it looks and feels, and another one is how it operates. So in those cases where your product has both qualities, you will need both a design patent and a utility patent.
Okay, if I hired and paid a branding company to create a logo for my company and I collaborated, what paperwork or permission do I need from them for the 3 logos they created for me so that I own it and can use it and trademark it, etc.?
For any type of trademark or copyright, I advise people to ask for a full assignment of the rights to that property, of the full assignment of a trademark or the full assignment of the copyright. That way you can take it, use it anywhere you want, and modify it. Modifying being the key, particularly in copyright. You don't want some draconian copyright rules will be that like you could pay a blogger to write an article for you, and then they give you the article, but they keep all of the copyright. So the only thing you have a license for is using that particular version. So you modify a little bit, and then they're going to say it's an infringement of their of their copyright, and you didn't have a license to do that. But if you got the full assignment of the rights, you could modify it anyway. And the trademark being the same in the sense of you have a trademark today, and 20 years from now or shorter, you want to change the trademark. Now, you might not hire the same company to do that. You give them the design, and it might be very similar to the current. I mean, it's very common that trademarks evolve, and in those cases, if you don't own the rights to the design of the trademark, you'd have to hire the same company to change it. So always ask for a full assignment of the rights.
Okay, when sending a CAD file for a drawing, is it sufficient to have a statement inside the CAD file, or is it necessary to have a client sign a statement acknowledging your intellectual property?
Honestly, that question is simply too broad because I'd have to know the context of why the CAD file was being sent. And I say that because you could have all of the different scenarios that we were talking about. You could have a work for hire situation where it's an employer. You can have a contractor. A CAD file, because the issue there, and I deal with this a lot, is if you hire an outside company to design a widget to solve a problem, that would be in a CAD file, that widget might be eligible for a patent in itself. And a lot of times the company that hired you will try to argue that, well, the real invention was discovering the problem. And so they have part ownership, but then the company that designed it says, no, the whole invention was, our creative design. So it really needs to be discussed up front as to who owns the design. And I mean that by, who has the rights to make, use, and change the design. Putting the self-serving language in the document itself certainly never hurts. I never advise people not to do that. But the more important thing is to make sure that you have reference to the particular contract that you came up with to the company that you're sending it to. So there's so many different ways to answer that question, but that's just one of them. It just really depends on the context of why the document's being sent to the other company.
Okay, I have multiple businesses that have the same acronym with the same meaning, but different logos. Can I trademark this? I already researched, no one has it.
So yes, I would recommend that you get each individual. So to be clear, if you use them and put the superscript TM, you are trademarking them. You're just putting them that's a common law trademark. If you're making enough money off them to justify the cost, or you're disseminating, as I said, for third parties, you're allowing third parties to use it. But I definitely recommend doing a federal registered trademark. And in those cases, you would just register each individual trademark, and you list the services and types of products associated with each individual trademark. Seeing that, like, if you have multiple different lines of businesses, you can register each one of the different, what they call class, and each class is a different use of that same trademark, or even if it's a different trademark, slightly different, there might be a different class as well.
Is there any instance where an API software code design can be patented or trademarked?
Patented, yes. Trademark, no. I deal with patented API issues quite often. Where they come up is, suppose that you have two APIs, okay, from two different software applications. And now you create a software product that has its own API. And in that third API, the new API, let's say that it calls individual operations from the first two APIs that neither one of them could do by themselves, mixes the data in some way, and maybe even calls a third API in order to provide its own set of, its own output. That scenario would be considered, if you did enough, it would be considered non-obvious. Given the current two APIs, it'd be a non-obvious improvement, and that would be patent eligible. Trademark law really doesn't apply to APIs. Trademark is just the name and the logo associated with the product.
Okay, in civil court, if you try enforcing your patent pro se pauper, would that be a way to get a free patent attorney? And are there any resources for patent holders to potentially enforce a patent?
You can okay, so there's a lot to unpack there. A few people have been successful bringing lawsuits as pro se inventors with patents. Go watch the movie, was it Flash of Genius? And after you watch the movie, see if you still want to do it. Would be my first advice there. The second thing I would recommend is that you contact an IP litigation. You can find them on the internet. I'm not really affiliated with any of them, so I don't have a recommendation for any of them, but you can search for IP litigation financing. There are companies that you can partner with for obviously a share of the of the winnings, and they can evaluate the patent and see if it's worth bringing an infringement action. Just fair warning to anyone, if it goes all the way to court, a typical infringement action will cost about $1 million. So it's not for the faint of heart. And that's why pro se inventors have such a hard time, because if they bring an action like that against a major company, they can get flooded with paperwork. And so in those cases, the best option would be to partner with a financier of your litigation.
How is a method someone has created protected?
So a method is protected through a patent. Software code often being example of a method. One of the better examples that I worked on in my time was a patent on software code for doing image resizing using only integer operations. It was very, very complicated computer code, and he had various techniques that he was doing to avoid the need for floating point operations. And as a result, he was able to use your CPU and not your GPU. And you could argue that he was using an improvement to the performance of the computer, but the sequence of operations that he was using was in fact the method. And so that's how you patent a method, is typically through or how you protect a method is typically through a patent. And it doesn't have to be software code. It could be operating machinery. There's been plenty of patents on those things as well.
Okay, what range price should you pay an attorney to hire for trademarking? Also, how can we select an attorney that's qualified and experienced with intellectual property?
So the first thing that you should do to answer the first part of the question is, honestly, you shouldn't expect, even the simplest trademark is going to be cost, I would expect from a reputable law firm about $1,000 at least. The reason being, there's so much, it's not just the trademark, there's so much overhead that you have to pay for docketing. Because there's so many due dates and that sort of thing, communication with the patent office, that all has to come out of that fee. So that would be where I would say, give or take a few $100s, what you should expect. The way that you determine if they are a reputable firm is search for an IP intellectual property law firm, a law firm that specializes in intellectual property. Almost all of them will have at least one attorney that specializes in trademarks. Like, for instance, in my firm, we have one attorney that does it full time, and another attorney that does quite a bit, or a couple of attorneys that do quite a bit. I only do a little bit. So when I get a type of trademark, I would typically hand it over to one of my partners to handle, because they can handle it more efficiently. But if you identify a patent law, an intellectual property law firm, most of the time they will do mostly patents, but they'll almost always have reputable trademark attorneys there as well.
Okay, I'm going to just do one more question. And if I wrote a book and within that book I added an original poem, would that poem be under copyright protection simply because it's within the book?
In that case, if you write a book, I recommend that you do register it with the Copyright Office, and it would be protected there. However, I would actually recommend that you register the copyright for the poem separately if you are ever planning to use it outside of the context of the book. If it only has value in the context of the book, you probably only need to register the book.
Okay. Again, I think we're taking up a huge amount of time here, and you've been wonderful, Michael, to answer all these questions, but I think we could go on for ages still. So I'm going to suggest that anybody who didn't get a question answered, please just contact your SCORE mentor. And as Michael suggested, they can use Michael to answer those questions. And that would be the way to go if you're in the process of doing something, developing a business or something that might be patentable. If you work with a SCORE mentor, they will connect you with Michael. So Michael, thank you. This there are so many positive comments from people indicating this has been a wonderful session, and it certainly has. It's definitely generated a lot of questions. So very well done, wonderful examples, and thank you so much. And I will let you go. Everybody.
Anita, I will send you an updated copy of the presentation for today in the
Okay.
PDF format. I do ask that anyone that is using it, we're not going to bring a suit, but I would ask anyone that uses it, disseminate it in its entirety, because it does reference SCORE, and I'd like to give credit to SCORE for helping put it together. So for anyone that gets a copy of it, and if you send it out, send the whole presentation together. It's just what we're asking.
Well, everybody will get a copy of the presentation plus a link to the recording, so they will have access to all the information that's been discussed here. So,
oh, right. I just know from past experience, people will sometimes cut and paste certain parts of it out. We just ask that you give it, to make sure you give credit to SCORE for the presentation.
well, thank you again, Michael. Everybody have a pleasant afternoon, and we'll see you another time.